మళ్ళీ రివర్స్ ఓకే సరే రైట్ yeah please yes right so conciliation can be similar in many ways to mediation, yet it differs in one important respect. Conciliation refers to a mediation like process in which an impartial third party, the conciliator, is able to provide the parties with legal information and suggest solution to them. Right. For example, if the conciliator or mediator don't know the law, and if you ask him to enter into an agreement which is contrary to whatever be public policy or Indian Contract Act, then it is not enforceable. That means conciliator or negotiator, they should be well versed with the laws of the land. ఎలా అంటే అలా వచ్చి కూర్చున్న తర్వాత మీడియేట్ చేసి ఒక అగ్రిమెంట్ లోకి ఎంటర్ అయిపోండి అని చెప్పి సైన్ ది అగ్రిమెంట్ దట్ ఈస్ నాట్ ఎన్ఫోర్సబుల్ యు అండర్స్టాండ్ ఎవ్రీథింగ్ షుడ్ బి అకార్డింగ్ టు ది లా ఆఫ్ ది ల్యాండ్ రైట్ సో హియర్ conciliators can be much more directive and interventionist than interest based mediators. Right. So he is intervening. He will asking the parties to enter into an amicable settlement with respect to their legal rights. For example, in Arbitration Conciliation Act 1996 and the UN Citral Rules on International Commercial Conciliation 1985, conciliator cleared that conciliator under the documents, apart from assisting the parties to reach a settlement, is also permitted to make proposals for settlement. He can make a proposal for settlement, formulate the terms of a possible settlement. You are going before the conciliator with a plan, settlement plan. Even he can redevise or reformulate the settlement. He can propose a new settlement also, right? Permitted to make proposals for a settlement and formulate the terms of a possible settlement, reformulate the terms, and this is clearly different from the role of a mediator traditionally, who is regarded as a facilitator and does not have a proactive role. What is meant by proactive? Actively he is participating. This is not the case with a mediator. You see, mediator simply makes the parties understanding. Conciliator, he plays an interventionist role. Interventionist. Have you heard about the word interventionist? Interventionist. கேள்விப்பட்டிருக்கீங்களா? For example, one day suddenly you got a heart attack. Suddenly heart attack ఉంది. అర్థమైందా? హార్ట్ అటాక్ వచ్చింది. వెంటనే ఎక్కడికి పోతారో కార్డియాలజిస్ట్ దగ్గరికి పోవాలి. ఏ హాస్పిటల్ కన్నా హాస్పిటల్కి పోతే హార్ట్ అటాక్ ఉందా ఎంత డాక్టర్ కిటికి పోనా వాళ్ళు ఏమంటారంటే interventional cardiologist. You understand? You got a problem. What you got a problem? You got a blockage in your heart. They will intervention. They will clear the blockage. Otherwise, they will put some angiogram. They are intervening in the middle and see that your problems got solved. Right? If you get heart attack, you cannot go to nephrologist, you cannot go to neurologist, right? Here also, conciliator is an intervention cardiologist. Understand? You are having certain problems, so you have to approach the right conciliator. Adugucho. Huh? He is not comfortable with this chair. Huh? Huh? You have back problem. I have every problem. Right? No, no. One day I was here. He came to me. Sir, tell me. You are wearing bracelet. I also, by seeing you, I have purchased a new bracelet, and he showed his bracelet. Yeah, very good. Sir, my your bracelet is more bigger than my bracelet. Right. ఎక్కడ కొన్నా షాప్లో కొన్నా రైట్ no. There is one concept is there that is known as I have forgotten concept. If one person can do, you can also do. ఒక వ్యక్తి చేసినాడు అనుకోండి మీరు చేయొచ్చు. If one person is becoming an IAS officer, why can't you become that IAS officer? అవునా కాదా? ఫర్ ఎగ్జాంపుల్, ఐ ప్రిపేర్డ్ ఏ కుక్ డిష్, బిర్యానీ చేసిన. ఎలా బిర్యానీ చేసినావు అంటే చూపిస్తాను రా అని చెప్పి యూ టేక్ టు ది కిచెన్, యూ పుట్ రైస్, అదర్ పర్సన్ ఆల్సో పుట్ రైస్, యూ పుట్ ఎవ్రీథింగ్, అదర్ పర్సన్ ఆల్సో పుట్ ఎవ్రీథింగ్, సేమ్ ఇంగ్రీడియంట్స్, సేమ్ బిర్యానీ, right? Same. If one person is able to do, why can't you do? Only thing is ingredients vary. He studied for 14 to 15 hours a day, and you studied for 1 hour a day. He became an IAS officer. You become a bill collector. No, no. That is the concept recognized by psychologists. ఒక వ్యక్తి చేయగలిగినప్పుడు మీరెందుకు చేయలేరు? There are certain what is called things are there, right? గురుజీదా ఉన్ పేరన్నా? No. Godwin, right? Godwin, right? Yes. So, heroine అవుతాన్నావా? Right? Please listen. Once you come into the class, learn something. Take with you something knowledge. Every day is a learning day for you. Now, where you have to go? Interventional cardiologist. You understand? So here also, who is conciliator? Interventional. He will know which artery is blocked, which is blocked, and he will give one angiogram or bypass surgery or open heart surgery. He will perform and clear all your problems. Here also you are going before a conciliator. No, no, that is the meaning of interventionist. He will interfere in the middle, see what is your problem. He will make a scan of the problems, pros and cons he will decide whether to go for angiogram, bypass surgery, open heart surgery, or whatever it may be. Then he will do the things. Likewise, conciliator is also having, he will see certain pros and cons. புரிஞ்சுதா? என்ன புரிஞ்சுதா? சொல்ல. International consultant, interventional cardiologist, right? You very good. లాలో అనర్గళంగా నోరు తిరగాలి. లా ఉందా ఒకటి జడ్జిమెంట్ పోయి యూ హ్యావ్ టు ట్విస్ట్ ది టంగ్ లైక్ ఎనీథింగ్. కొన్ని మాటలు నోట్లోకి రావు, కొన్ని మాటలు నోట్లోకి వాయిల వరాదు. బిగ్ బిగ్ టెర్మినాలజీ ఇస్ దేర్ ఇన్ లా. We don't speak. Interpretation of statutes, 50% don't speak. Statute, they don't know how to pronounce. Statute, some ways they will do. No, while I am giving this internal question paper, I will ask, what is your exam today? Sir, interpretation of state. Very good. Take. Interpretation of state. Yes, very good. Go. ఇంకా వానికి ఏం అడగకూడదు. ఇంకా వాడు స్టేట్ అన్నాడంటే ఇంకా అయిపోయి. హీ నోస్ ఎవ్రీథింగ్. Interpretation of state. Take. Right. Now, this is how the basic system is there. I have seen one cartoon. One monkey is there. One fish is there. You know fish, right? One monkey is there. One fish is there. One snake is there. One crocodile is there. One parrot is there. And one person is telling, our basic education system is like this. If anybody wants to get the seed, climb that tree. So fish has to climb the tree. Then only he will get seed. Can fish climb the tree? No, that is our basic education system. అందరినీ కట్టేయండి ఒకే దాంట్లో. You do all the things, right? That differs. అర్థమైందా? Don't think that it is simply wearing the coats and gowns and go before judges, take selfie and post it in your DP. Right? I have seen so many people. Enrollment, DP. The DP is for ever. That's it. That is the first DP, last DP. Right? Godwin, right? Right. Now we are going to see advantages of mediation. Right. So, advantages of mediation. Both mediation conciliation is said to offer better time and cost efficiencies than determinative process. That means arbitration or litigation. They are known as determinative process, determined in the courts. Arbitration before the arbitrator, litigation is before the courts. They are cost effective, time effective. You go before arbitration, he will follow certain procedure. You go before the courts, they will follow certain procedure. It is an informal and flexible process which can be tailored to accommodate the cultural, structural, commercial differences. You know, differences may not be only with respect to business differences. Problems arise due to cultural differences. Problems arise due to structural differences. For example, you are working in a company, right? It's an Indian company. Suddenly it has been taken over by a foreign company. Definitely you will be having problems with respect to their cultures. Their cultures, you are conflicting with the cultures, conflicting with structures. Their working styles are different. Your working style is different. Differences arises. Difference means difference only. Every difference has to be answered. So it can be tailored and you go to a tailor, he will stitch your cloth according to your measurement. Tailor ఏం చేస్తాడో మీ మెజర్మెంట్ ఎలా ఉంటుందో అలా కుడతాడు. కన్సిలియేటర్ కానీ మీడియేషన్ కానీ ఏమవుతుంది, మీ డిస్ప్యూట్స్ పైన బేసింగ్ అపాన్ యువర్ ఇంటరెస్ట్ దే ఆర్ గోయింగ్ టు సాల్వ్ యువర్ ప్రాబ్లం టైలర్డ్ టు సూట్ యువర్ నీడ్స్. If you go to the courts, there is no such fit into measurement. Courts will go according to the law. So, however, the main shortcomings of mediation relates to its lack of finality. Arbitrator, finality. Whether you accept it or not, it's a deemed decree, enforceable, executable. There is no such thing in the mediation or conciliation. Finality, regard, it is not binding on you, right? And its uncertainty in relation to enforceability issues, right? The basic difference, main shortcoming mediation lo enti, There is no finality. Even if you enter into an agreement, it is not binding on you, and uncertainty in relation to its enforceability issues. But in some countries, even mediation agreement is enforceable. Right. While an arbitration agreement and arbitral awards are enforceable, arbitration agreement and arbitration awards are enforceable, recognizable. They are in their finality in mediation is totally dependent on the parties consent to agree on settlement, right? It is depending on the parties, right, and binding upon them and enforceable. Arbitration agreement, you like it or not, binding, but it is not here binding unless and until you accept it, right? Now, the advantages of mediation can be summarized. Mediation as an informal process where a party selected neutral assists the disputing parties in their negotiations. So it's an informal process. He will make two parties sit and he will assist them to reach a negotiation. Third party facilitates and coordinates the negotiation of the disputing parties. It's a process where third party is coming, facilitates, negotiates, tell your rights, tell your rights. Rights means rights arising under different laws. Different laws. He will tell the rights. He asks them to reach a amicable settlement. Mediation is trying to get two people to do that which they least want to do, talk to each other. It empowers the parties to work towards a mutually acceptable outcome. So both the parties should accept mutually inclusive but not exclusive. Mutually ఇద్దరికి amicable గా ఒక సెటిల్మెంట్ ఉండాలి. Both has to accept. Right. The mediation model, so and so. Though through a process of recognition and empowerment, parties are provided with opportunity to transform the way they relate to each other. Right. Mediation process is a flexible one. It's very flexible one. There is a structure to the mediation process. It is not rigid but rather fluid in nature. Rigid means which is not changeable. It's fluid means it can be changed. Right. Why you are resorting to mediation? It reduces the court waiting list, the workload on the judiciary, cost to disputants, and cost to the state sponsored judicial system. It reduces the burden of the courts. That's why even in the constitution there is one concept is there, alternate, what is called alternate remedy. Alternate remedy. Straight away you cannot go and invoke the jurisdiction of the high courts and supreme courts. The courts, you have to write one sentence in the writ petition. Every writ petition, in any writ petition, you have to write one sentence. I don't file any case, I don't sought any alternate remedy. Unless and until there is no alternate remedy, you cannot invoke the jurisdiction of the high courts and supreme courts. That is the constitution says. If any alternate remedy exists there, మీకు ఇంకొక రెమెడీ ఉంది అంటే మీరు కోర్టుకి రాకూడదు. ఎక్కడికి పోవాలి? అక్కడికి వెళ్ళాలి. యు అండర్స్టాండ్? Straight away you cannot invoke the jurisdiction under 32 and 226. Alternate remedy is there. For everything alternate remedy is there. First you go there. then only you can invoke this jurisdiction. Judicial review, alternate remedy. Even all the tribunals are alternate dispute resolution mechanism only. For example, state administrative tribunal, central administrative tribunal, different tribunals are there. எல்லா கேஸுக்குமே கோர்ட்டுக்கு போகக்கூடாது. There are different mechanisms are there. For example, you are a state government employee. If you have any grievance, you cannot come to the court. First, you have to approach state administrative tribunal. You are an IAS, IPS officer. Go before central administrative tribunal. Different mechanisms are there in the hierarchy. Unless and until you exhaust the alternate remedies, you cannot come to the courts first. எல்லாத்துக்குமே கோர்ட்டுக்கு வரக்கூடாது. எல்லாம் ஒரு செப்பரேட் ஸ்ட்ரக்சர் இருக்கும். For example, consumer dispute forums is there, state forums are there, national forums are there, human rights commissions are there. What are they? They are all again alternate dispute resolution mechanisms. First to exhaust those remedies, then only you can come here, right? So here you are reducing the workload of the judiciary, cost to disputants and state sponsored judicial system, right? In China and Japan, mediation conciliation is used as a primary means of dispute resolution. Primary means of dispute resolution. If you see Singapore income tax, it is only 40 pages. Singapore, if you read Singapore income tax, entire tax is only 40 pages. Our income tax is this much, right? It in income tax act 1961 na 61 na 61 read with CBDT rules and regulations. Central Board of Direct Taxes. ఇంత ఉంటుంది. సింగపూర్లో 40 pages ఉంటుంది ఇన్కమ్ ట్యాక్స్ అంతే. You know why? They all good taxpayers. We will evade the tax. That's why our book is like this. పాత ఒన్ను పన్నువో పాకలన్నా ఒన్ను పన్ను. అండర్స్టాండ్? చూస్తే ఒకటి, చూడకపోతే ఇంకొకటి. If madam is seeing you, you will pretend to be listening. If she is not there, take the phone. See. Phones etanglana last la your life will be cell phone. You know the meaning of cell phone? Cell and jail. So you will be in the jail. Throughout your life, you will be in cell only. Just leave the phones. Open your minds. Re-engineer your minds. You can go to gym. You can do gym for 3 or 4 hours. But you cannot sit and read for 1 hour. ఏం చేస్తుంది? అవునా కాదా? ఎన్ని అవర్స్ జిమ్ చేస్తావు రోజుకే? 3 hours. How many hours you read? No. If you want to read for more hours, there is one technique is there. You can sit for 14 hours per day. I will tell you how. Right? You go to a stationery shop, buy one Fevistick or Fevicol, put it in the chair, sit. Yes, there is a bondage between you and the chair. Yes, you can sit for 14 hours. Yes, Fevistick technique. No, don't follow this technique. Then something will happen to you. Right? Different? Yeah, please. Focus. You know, sun is there. Sun is having sun rays over everybody. Nobody gets hurted. If you take a magnifying glass, what happens? It can lighten the paper. Your focus is also like should be there. మీ థాట్స్ ఎయిమ్స్ అన్నీ కూడా ఫోకస్ చేశారు అంటే యు ఆర్ బౌండ్ టు అచీవ్ దట్ థింగ్. డోంట్ డిస్ట్రాక్ట్ యువర్ ఫోకస్. You focus only on one thing. Focus on only one thing. That is your cell phones. Right. Whether you eat it or not, that does not mind. It should be recharged full. 90 days package, 720 rupees. 2 GB net per day, that is important than your food and things. Read so many books. అంతే కదా, ఎదురుందా ఏమున్నా లేకపోయినా టెలిఫోన్లో మొబైల్లో మాత్రము ఈవెన్ ఇఫ్ పాసిబుల్ ఇయర్లీ రీఛార్జ్ 3 GB per day, that is enough for me, right? Right, we'll shift on next chapter. Yeah, there is no break for you. Sit in your chair and take a break. Don't go outside. Huh? అర్థం కాల వాడరా. There is no outside break for you, only inside break. అక్కడికి పో, కిందికి పో, కిందికి పోతే అరుస్తారు, నిన్న అరిచారు, పంపించారు చైతన్యం, రైట్? హర్షిత, ఏం ఫోన్ మళ్ళీ వెంటనే కాల్ వచ్చిందా? యువర్ కాల్ ఈస్ మోర్ ఇంపార్టెంట్ దాన్ యువర్ క్లాస్. వాట్ we need is, right? Yes, you do whatever you want, go before Jesus. Jesus, I confess. That's it. Your every sin will be vanished, right? Sorry, దానికి ముందు చూడు, వైండింగ్ దానికి ముందు లిక్విడేషన్ దానికి ముందు అది అయిపోయింది. నెక్స్ట్ ఇది అయిపోయింది కాదు, ఒక్క నిమిషం, 4 తీసుకో. ఇదేనా మనం చెప్పింది? ఇదేనా ఆర్కోరం అయిపోయింది? అయిపోయింది, లిక్విడేషన్ పోయినా. నెక్స్ట్ తీసుకో 5 ఫాస్ట్ ట్రాక్ ఇన్సాల్వెన్సీ. చెప్పి నెక్స్ట్ తీసుకో. ఒరే 4 నిమిషం. నెక్స్ట్ తీసుకో. అదే చెప్తున్నాం మనం, ఇనిషియేట్ స్టార్ట్ అయిపోయింది, కొంచెం ఉంది ఇంకా. నెక్స్ట్ పవర్స్ అండ్ డ్యూటీస్. ఇక్కడ లేదు పైకి తీసుకో, ఇక్కడ దాకా వచ్చి ప్రొఫెషనల్ అసిస్టెంట్ దాకా రైట్. ఎంతొందు కడియాలి ఫీల్డ్ ప్రిన్సిపాల్ పురిలా. యా ప్లీజ్, రైట్? So yesterday, yeah please, Sharma, you are unable to understand opinion changes. Understand? ఒక మనిషిని చూసిన తర్వాత ఒపీనియన్ చేంజ్ అవుతూ ఉంటుంది. దట్ ఈస్ ఇది, ఇట్స్ అప్ టు యూ. Yeah please, right? So yesterday we have seen, once if the corporate insolvency resolution process fails, the next thing is you have to go before the adjudicating authority, get an order for winding up, right? Get an order for winding up. Now the insolvency resolution process will be entirely changed into winding up process, liquidation process. Now liquidation winding up order is passed. Once winding up order pass panna, next what is going to happen? Official liquidator will come, right? By virtue of the winding up order, the powers of the interim resolution professional as well as the board of directors, everything will comes into hands of the official liquidator. Now he is having certain duties and functions, right? He can sell the assets, including actionable claims also. అన్ని అమ్మొచ్చు ఇంకా, ఎందుకంటే వానికి ఫుల్ పవర్స్ వచ్చింది. అది ఆడుకో వెళ్ళిపోయింది, అది ఆ చాప్టర్ కావాలి, ఆ స్లైడ్. నెక్స్ట్ 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 ఇక్కడే రైట్. సో నా చిన్న స్లైడ్ పోటాయినా పెరియ స్లైడ్ పోటాయినా, యు ఆర్ నాట్ సీయింగ్ ద స్లైడ్, ఇట్ ఈస్ ఓన్లీ ఫార్ ఫార్మాలిటీ. అది ఏమంటే nobody is seeing the slides. Again they want a big cinema, big slide. What you want? For what? 70 mm scope, right? ఏం నీలం దుర్గా, నీ పేరు బాగా గుర్తుంది నాకు, రైట్? ఎస్, రైట్. ఇప్పుడు వానికి పవర్స్ వస్తాయి. టెక్నికలీ ద అఫీషియల్ లిక్విడేటర్ ఈస్ హ్యావింగ్ ది పవర్స్. He may obtain any professional assistance from any person or appoint any professional in discharge of its duties, obligations and responsibilities. So official liquidator can take the assistance of professional, for example lawyers. He can take the assistance of lawyers, then he can sell the assets also to yeah, please, you are all matured enough. Nobody should be there to warn you. Be silent, be silent. You are all grown up children. Once you come into the class, maintain. Your life is interconnected, you understand? Prati or action interconnection irko. Everything will count in you in your lifetime. Every rupee counts. Every action counts. If you want to reach the biggest heights of your life, your every action will be counted. Rajinikanth Varnala superstar ala. Yavalava itniyo panna. Likewise, every day you have to do. Once time comes, the universe bestows with you the best thing. Straight away, nobody will become superstar or so many things. Every day they will perform. I have seen one interview of our megastar Chiranjeevi. He was giving one interview. He was in the shootings outdoor in somewhere forest. He was in the shooting. Then director has asked him, if you want to take leave, you take leave and go and spend with your children and come. Leave anna, leave எடுத்துட்டு shooting na cancel பண்றேன், நீ போய் you spend the time with your family and come. He said, after 50-60 years I can spend some time with my children, but this is the time for my career. So every day I want to shoot. I want what is called have a growth in my career. Every day is a thing. So that should be అలా చేశాడు కాబట్టి ఈ రోజు అలా ఉన్నాడు అతను. You can spend time with your kids later. After some time I can spend, but this is my career, so I cannot what is called postpone my career now. So every action counts. This is the way you have to go, right? To invite and settle claims of creditors. Creditors are different, claimants are different. So he is inviting the claims. He will publish in the newspaper that the company is going into liquidation. Company on the liquidation pokordu, that means we are going to sell the company. If anybody is having the claims settlements, please come. So here creditors are different, claimants are different. Creditors means who give the money, claimant means whoever is lost. Hello, enna You are all grown up. Here I should not shout. அது நீங்களே உணரணும். You have to feel for that. You are all grown up children. Basically you are good children. But only thing is you are not accustomed to sit work for longer hours. Advocate profession na chumma కోర్టుకు పోయి వంద useless. It needs a lot of physical and mental. I think whoever is going to courts they know. ఊరికే రాదు అవన్నీ. సింపుల్ బ్లాక్ అండ్ వైట్ కోట్ వేసుకుంటే ఓన్లీ యూ కెన్ బికమ్ అన్ అడ్జోన్మెంట్ లాయర్స్. యు నో ద మీనింగ్ ఆఫ్ అడ్జోన్మెంట్ లాయర్స్? వాయిదా. సార్, requesting time. They know only two words. Requesting time. That lawyer you will become. You don't argue. Don't think. Whenever you are arguing a first appeal before the courts, entire day you have to argue first appeal. Why? Again you are reappreciating the entire evidence in the first appeal. First appeal, they may reverse the judgment of the lower courts. Lower court la 3 வருஷம் கேஸை நீங்க 3 நாள் ஆர்கியூ பண்ணணும். ஃபர்ஸ்ட் அப்பீல்ல ஸ்டாமினா இருக்கணும். ஒரு half an hour ஆர்கியூ, half an hour 10 நிமிஷம் ஆர்கியூ பண்ணி அவ்வளவுதான். You lost your case. என்ன கார்த்திகா? யாருக்கு எக்ஸ்பீரியன்ஸ்? உங்க சீனியர் எக்ஸ்பீரியன்ஸா? அவர் கூட ஆன் உண்டார கோர்ட்ல. ரைட். நோ ஸ்டாமினா. ఎంత స్టామినా ఓనో? ఫిజికల్ స్టామినా ఓనో, మెంటల్ స్టామినా కావాలి. మెంటల్ స్టామినా ఇస్ మోర్ ఇంపార్టెంట్ దాన్ ఫిజికల్ స్టామినా. I can argue for 2 days, 3 days. I can irritate the judge, you know. Judge says, have you finished your arguments? No, my lord, give me another 2 days. I know that there is nothing in my case. I am going to lose. Why should I want to lose that much easily? I will irritate the judge and lose. Judge chumma emonra nu rendu naal pesaran naanu. Anyway you are going to dismiss my case. You hear my case. You hear my case. After 2-3 days you can dismiss my case. Ante kada ఊరుకు వదలకూడదు. நான் కష్టపట్టు లా படிச்சேன் సార్. 3 లక్షం పే பண்ணி లా படிச்சேன். I am going to irritate you. Please sit down. I will argue the case. Right. You irritate the. Sometimes judge says, உனக்கு என்ன வேணும்? My lord, order. Go, take the order. Go. Right. Sometimes it will happen. Stamina should be there in the courts. Right. Stamina உட்காண்டல ஆர்கியூ பண்ணக்கூடாது. நின்று ஆர்கியூ பண்ணணும். பெரிய மைக் இருக்கும். மார்னிங் டிஃபன் சாப்பிட்டு வந்தா 3 hours, no break, straight away arguments. I have a wonderful experience with different erstwhile judges who has an advocate. Now they have become judges. I have a wonderful experience with those people also. I know how to irritate the judges also. I will irritate the judges. No, my lord, still is there. One evidence I will appreciate. Let me read. Reread. Time is over. Okay, tomorrow. This is how you have to learn the tactics of advocacy. పురంజిదా? మెంటల్ స్టామినా ఉండాలి, ఫిజికల్ స్టామినా ఉండాలి, చాలా ఉంటాయి ఈ ప్రొఫెషన్లో. రైట్. టు ఇన్వైట్ అండ్ సెటిల్ ద క్లెయిమ్స్. நல்லா சாப்பிடணும். இப்போ சாப்பிட்டா கோர்ட்டுக்கு போய் தூங்கலாம். రైట్. యూ క్యాన్ స్లీప్ ఇన్ ది కోర్ట్స్. రైట్. ఏం గౌతమ్, నువ్వు రెగ్యులర్లీ ఇర్రెగ్యులర్ చూస్తా ఉన్నా నిన్ను కూడా. టు ఇన్వైట్ and settle the claims of creditors and claimants, distribute proceeds. You are getting the amount that should be in accordance with the code. Previously it was under the Companies Act. Proceeds, you are getting the amount from the selling the assets, everything. Now what you have to do, you have to settle all the claims of the creditors, settle all the claims of the claimants. ప్రీవియస్లీ ఎలా అంటే డబ్బులు అలా ఇవ్వకూడదు. ప్రొసీజర్ ఉంటుంది. దట్ ప్రొసీజర్ దేంట్లో చెప్పింది? ఇన్సాల్వెన్సీ అండ్ బ్యాంక్రప్సీ కోడ్. ప్రీవియస్లీ ఇట్ వాస్ టోల్డ్ ఇన్ ది కంపెనీస్ యాక్ట్. నౌ ప్రొవిజన్స్ ఆఫ్ ది కోడ్. నెక్స్ట్ వన్, టు ఇన్స్టిట్యూట్ ఆర్ డిఫెండ్ ఎనీ సూట్. He can file suit on behalf of the company. If any suit has already been filed in behalf of the company, by virtue of the liquidation order, it stands in the name of the official liquidator. కంపెనీ పైన ఎవరన్నా కేసు ఫైల్ చేస్తుంటే కంపెనీ వేరే వాళ్ళ మీద కేసు ఫైల్ చేస్తుంటే ఏమవుతుంది? హూ ఈస్ గోయింగ్ టు రిప్రజెంట్ నౌ అఫీషియల్ లిక్విడేటర్, వెదర్ ఇట్ బి ఏ సివిల్ ప్రొసీడింగ్స్, వెదర్ ఇట్ బి ఏ క్రిమినల్ ప్రొసీడింగ్స్, official liquidator is empowered to institute, defend any suit, prosecution, other legal proceedings, civil or criminal, in the name of the behalf of the corporate debtor. So they want to take some rest, they went long. Right. మీకు వినడానికి ఇంత కష్టంగా ఉంటే నేను కంటిన్యూస్గా 2 hours చెప్తాను, నాకు ఎలా ఉంటుంది? ఐ డోంట్ మైండ్, ఈవెన్ అనదర్ 2 hours has been given to me also, right? I don't mind for anything, you know, because I don't have mind, right? Right. To investigate the financial affairs of the corporate debtor, he can even investigate affairs into the company for what? Undervalued or preferential transactions. For example, 3 creditors are there. They have given money to the company. Before this proceedings, company has transferred the assets to the creditor for least amount. ఒక క్రెడిటర్ ఫేవరెట్గా ఉంటాడు, కంపెనీ ఏం చేసింది? వానికి ట్రాన్స్ఫర్ చేసేసింది ప్రాపర్టీని. నువ్వు తీసుకెళ్ళిపో, మై కంపెనీ ఇస్ గోయింగ్ లిక్విడేషన్, యు ఆర్ నాట్ గెటింగ్ ఎనీథింగ్. తక్కువకు అమ్మేసింది. దట్ ఈస్ నోన్ యాజ్ అండర్ వాల్యూ. Under value transaction, if anything happens, he can investigate into this affairs. Preferential transaction means to choosing one creditor over the other creditor. Preferential transactions will be there. ఇవన్నీ కూడా మళ్ళీ ఏమవుతుందంటే మళ్ళీ మీరు కోర్టులో ఫైల్ చేసుకొని బ్యాక్ తెచ్చుకోవాలి ప్రాపర్టీస్ అన్నీ కూడా. బిఫోర్ ద లిక్విడేషన్ ఆర్డర్ ఈస్ బీన్ పాస్డ్, బిఫోర్ ద 1 year ముందుగానే అమ్మేశారనుకున్న ప్రాపర్టీస్ అన్నీ కూడా మళ్ళీ ఏం చేయాలి? వీడు సూట్స్ ఫైల్ చేసుకొని ఈ ప్రాపర్టీ అన్ని తెచ్చుకోవాలి మళ్ళీ కంపెనీకి. అండర్ వాల్యూ ట్రాన్సాక్షన్, ప్రిఫరెన్షియల్ ట్రాన్సాక్షన్. వై? దిస్ హాస్ బీన్ done with the intent of deceiving the creditors. You understand? Preferential transactions, preference over other creditors. There should be order in the payment, but you are not doing. You are paying different creditors. Different transactions unna kuda nu malli court lo case file cheskoni you have to bring all those things. To take such all actions, steps or to sign, execute and verify any paper, deed, receipt, document, application, petition, affidavit, bond or other instrument for such purposes, and use the common seal. Companies having the common seal, right? He can take all such actions, he can sign. So ఇప్పుడు వాడు ఏం చేయొచ్చు? He can sign all the documents on behalf of the company. Documents, paper, deed, receipts, instruments, petition, affidavits, bonds, everything as may be necessary for liquidation, distribution of assets, and in discharge of his duties and obligations to function as a liquidator. Right. Now, whenever he thinks that he needs some order of the court, then he may even make an application to the adjudicating authority for such orders or directions as may be necessary for liquidation of the corporate debtor and to report the progress of the liquidation process. The adjudicating authority says, once in a month, file a report of your progress, how far the liquidation process has come. கோர்ட் என்ன சொல்லணும்னா மந்த் நீ என்ன பண்ணணும்? ஒரு ரிப்போர்ட் ஃபைல் பண்ணு, எவ்வளோ வரைக்கும் வந்து ப்ராசஸ். We have to know. That is known as information memorandum he has to file. This is the stage where I have reached. This is the stage. Finally, you have to produce a final report. On the basis of the report only, adjudicating authority passes an dissolution order. Dissolution order. Winding up is different. Dissolving the company is different. Winding up means process. Dissolution means everything has been completed. Company is dissolved. It is no more in existence now. Right? So, and to report the progress of the liquidation process in a manner to perform such other functions as may be specified by the board. So, Insolvency and Bankruptcy Board of India. Now, he got all the money, he sold the assets. He has taken money from all the creditors, everything. Now he is having money. What he has to do? Distribute. இப்போ காசு இருக்கு அவங்க கையில கம்பெனியை மூடணும்னா கடன்காரர்களுக்கு என்ன கொடுக்கணும் காசு இருக்கு now he wants to distribute the assets as per the procedure prescribed under the code, right? Now liquidation commencement date means the date on which proceedings for liquidation commence in accordance with. Now this is very very important. Order of distribution of assets. This is the order in which you are going to distribute the assets of the company. This powers and functions of liquidator is a definite question in your question paper. Order of distribution of assets is also another question in your question paper. How you are going to distribute? எப்படினா அப்ப distribute பண்ண கூடாது. There is one order is mentioned here. Right, we are going to see. First one is insolvency resolution process cost and liquidation cost. First, what you have to pay? Insolvency resolution process cost and liquidation cost. గౌతమ్ నిద్రపోయింది అయిపోయిందా పడుకోలేదా నేను చూస్తా ఉన్నా right, no issue, sleep, it's your fundamental right. You are not accustomed to sit for these hours, that's why you are getting sleep. Whether your mind is not accepting the things, you get sleep, ante kada. If you go to a nursery class, small kids, they will be sitting in the table, one person is writing, one kid is sleeping. Why? వాళ్ళు అలవాట్లేదు, ఇంట్లో ఉండి వచ్చారు, వీళ్ళకన్నా అలవాట్ల నిద్రపోతాను గౌతమ్ పడుకొని తూగుతాను పర్లేదు రైట్. They are kids, you are grown up kids, that's the only difference, right? So first ఏం కాస్ట్ పే చేయాలి? Insolvency resolution process cost and liquidation cost, that is the first we have to pay, right? Second one is workmen dues. Workmen dues 24 months preceding the liquidation commencement date. Workmen means whatever be the let it be provident fund, gratuity, everything dues. Simply it tells workmen dues. Workmen dues unte 2 years mundu edanna pending undi ante first em cheyali? First you have to pay those workmen dues. Third area is secured creditor. Secured creditor who has relinquished security. You understand the difference between secured creditor is having properties or there. Secured creditor is having property. He is having his own remedies. You understand? Secured creditor ante enti? Company's properties has been, that is known as, terminology in the Companies Act, charge over the assets of the company. Em Sharma, gurtunda charge? What are the different types of charges? Bus charge, railway charge, aeroplane charge. Very good. Floating charge, fixed charge. Right. Charges. I know this charge only. Right. Sharmaku nidrastanu, nidrapothanu. Right. Secure. Here you see, he is having separate remedies is there, but he is not pursuing that remedy. He is relinquishing that remedy and he is coming and sailing in this process. వాడు ఏం చేస్తున్నాడంటే, I am not going and filing a separate remedy. I will relinquish the security and I will sail with this. నేను ఇక్కడికి వచ్చి నేను క్లెయిమ్ చేస్తాను అంటున్నాడు. దాన్ని రిలంక్విష్ చేసేసాడంటే ఆ ప్రాపర్టీ ఎవరు తీసుకుంటారో, లిక్విడేటర్ తీసుకుంటాడు. You understand? He is having one secured property. Liquidator is telling, you are having secured property. You go and file the suit or you come with me. I will come with you. Then you relinquish the security in favor of me. I will sell the property. You can come in the list. நீ இந்த லிஸ்ட்ல வரலாம். நீ உன் ப்ராப்பர்ட்டி இருக்கு, நீ செப்பரேட்டா கேஸ் ஃபைல் பண்றியா இல்ல ப்ராப்பர்ட்டி மேல ரைட்ஸ் விட்டுட்டு என்னோட வரியா? நீ ரைட்ஸ் விட்டுறா, அப்ப ரைட்ஸ் என் பேரு மேல விட்டுட்டுனாக்கா ப்ராப்பர்ட்டி வித்துட்டு உனக்கு காசு கொடுக்குறேன். So third important person is secured creditors who has relinquished the security. Right. Workman is different, employees are different. Workman is different, employees are different. Fourth is employees wages and unpaid dues 12 months preceding the liquidation commencement date. Right. Next one is unsecured creditors. Again, if the amount is left only, they are going to get unsecured. You understand? If the amount is not sufficient, what they have to do? Simply they have to go home. அவ்வளவுதான், வீட்டுக்கு போகணும். காசு இல்லை, வீட்டுக்கு போ. லாஸ்ட் ஒன் யாரு? சென்ட்ரலா? Previously it was in the first. As per Companies Act, taxes due to the government in the priority list. Now insolvency, even income tax act should be read in consonance with insolvency and bankruptcy code only. You understand? Straight away your claims also been relinquished. That's it. You cannot claim as per your thing. Income tax also, no income tax. First these should be paid. If anything is left only, then you are going to get it. Central or state government. Next, secured creditor who has enforced security interest. Previously relinquished security, here who has enforced security. Next one is remaining debts and dues. Now lastly shareholders will come. Yeah, lastly shareholders will come. Preference shareholders. You know the meaning of preference shareholders? There is a preference shareholders. Ram Sharma, preference shareholders అంటే ఏంటి? దేనికి ప్రయారిటీ? దేని మీద ప్రయారిటీ? Next one is preference shareholders. Last one is equity shareholders or partners. Right? This is the area in which you have to settle all the claims. You understand? Once corporate insolvency resolution process fails, then a petition is filed in the adjudicating authority. Adjudicating authority passes an liquidation order. The powers of the insolvency resolution professional comes into the hands of the liquidator. Liquidator is having certain powers and functions. He will sell the assets, settle the liabilities in this order. Right. Now, once all this is settled, he will file a report with the adjudicating authority. எல்லாம் முடிச்சிட்டா விட்டு என்ன பண்ணுவான்னா, கோர்ட்டுக்கு போய் நான் எல்லாம் முடிச்சிட்டேன், I have completed everything in this process, The company has now don't have any assets. The company don't have any liabilities. ఇంక కంపెనీ ఏం లేదు ఇంకా. There is no such thing in the companies. Right? Again, the adjudicating authority, after satisfying itself, it passes an dissolution order. That means the company is no more in the eyes of the law. Right? You see, company has commenced by virtue of law. By virtue of law. Company's life has been closed by virtue of law. Company existence eppadi vandadu by virtue of law. Registrar of companies. The registrar of companies has given you one certificate of incorporation. That is the evidence that company has come into existence. Right? Any days? Sleep is over. Right? All are sleeping. అందరూ నిద్రపోతున్నారు పడుకొని. Right? What's her name besides you? Huh? 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 Sin Sin. Sing Sin. Sincy. Right. So Sincy is sincere. Yes. In attending the class. Right. Yes. Now, yeah, please listen. Till uh, crocodile festival is there for you. Huh? Crocodile festival is still there for you. Not yet over. Right. అర్థమైందా క్రొకడైల్ ఫెస్టివల్ అంటే ఏం సినిమా అదే శంకర్ దాదా ఎంబీబీఎస్ ரைட் இன்னும் எதுக்கு நிறைய இருக்கு இன்னும் சாயம் 4 மணி வரை கிளாஸ் இருக்கு இப்பவே எப்படி ரைட் யா ப்ளீஸ் நவ் the adjudicating authority passes an dissolution order. Company's existence comes to an end. You take this order and go to the registrar of companies, file it under authority, which authority it has been registered. The registrar of companies will notify, he will strike down the name of the companies from the register of companies. Right? So register of companies register இருக்கும் அவன் கம்பெனி பேர் என்ன பண்ணுவான் அவன் ஸ்ட்ரைக் பண்ணுவான். That means company is no more in existence now. Here he can sell the assets. Who? Liquidator can sell the assets. Whoever is purchasing the assets, straight away they can go to register office and get the asset registered. Court order ద్వారా I am going to purchase these assets. By virtue of the liquidation order, I purchase these assets. Straight away, you just take that court order, your what is called that name order, straight away go to register office, register. సరిపోతుంది. By virtue of liquidation order itself, there is no separate order necessary. By virtue of liquidation order తోనే మీకు వచ్చేస్తుంది అక్కడికి మీకు పవర్స్ వచ్చి సపరేట్గా మళ్ళీ కావాల్సింది లేదు. రైట్. So now one portion is over. Corporate insolvency resolution process. How initiation, persons entitled, then what is going to happen, go before NCLT. No, why I am telling you is, if you write in this way, you are bound to get 70 plus. 70 plus. Very easy. First entity, who are entitled to file an corporate insolvency resolution process. 3%. Next, where you are going, adjudicating authority. Then interim resolution professional is appointed. So corporate insolvency resolution process, time limit is there 180 plus 90, fast track is 90 plus 45. Right. Now what happens? Interim resolution professional is appointed. He will do two things: committee of creditors, preparation of the resolution plan. Right. Now once resolution plan has been prepared, they go before NCLT, produce. If it is approved, go according to resolution plan. If not approved within the time limit, liquidation order is passed. Once liquidation order is passed, official liquidator will come into picture. He will sell the assets, settle the liabilities, he will complete everything, file a report with the adjudicating authority passes and liquidation order, take the order, go to register of companies, file, the company's existence will come to a end. It is a process. Very simple. Structure Purinjid. I think honors people got some booklet from me. Undada? Everybody you got, no? Right. Next one. Next one is winding up by the tribunal. Here see, liquidation order is passed by the tribunal, National Company Law Tribunal. Liquidator is taking the process. Here, tribunal itself wind up the process. That means under the supervision of the tribunal, the company is wound up. అర్థమవుతుందా? ప్రీవియస్ ఏమైంది? ఒక ఆర్డర్ పాస్ చేసింది, వాడు చేశాడు, ఇక్కడ మేమే చేస్తాం. వీఆర్ గోయింగ్ టు వైండ్ అప్ ది ట్రిబ్యునల్. That's what winding up by the tribunal. Tribunal supervision of the tribunal they will do. Right. We will see the difference between winding up and dissolution. Right. So the terms winding up and dissolution are sometimes erroneously used to mean the same thing, but in fact they are differ from each other. Right. Legal implications of these two terms are quite different. There are fundamental differences between them as regards the legal procedure. The difference is based on the legal procedure. Winding up is means by which dissolution of the company is brought about. Winding up అంటే ఏంటి అంటే డిజల్యూషన్ ని తీసుకొస్తాం. ఫస్ట్ వైండింగ్ అప్, సెకండ్ స్టేజ్. Winding up is the first step. Dissolution is the second step or last step. Right. The main purpose of winding up of a company is to realize the assets and pay the company's debts expeditiously and fairly in accordance with the law. If any surplus is left, it is distributed among the members in accordance with their rights. ఇక్కడ వైండింగ్ అప్, కంపెనీస్ లీగల్ ఎగ్జిస్టెన్స్ స్టిల్ దేర్. వైండింగ్ అప్ లో కంపెనీ ఎగ్జిస్టెన్స్ ఉంటుందా అంటే ఉంటుంది. ఎప్పుడు లీగల్ ఎగ్జిస్టెన్స్ ఉండదో? డిసల్యూషన్ ఆర్డర్ పాస్ చేసినప్పుడే ఉండదు. సో it may be noted that on winding up, the company does not cease to exist as such except when it is dissolved. Even after the commencement of winding up, the property and assets of the company belong to the company until the dissolution takes place. Right? Remaining we'll see. Got something today? ఏదన్నా మైండ్లో పోయిందా? గుడ్. లైవ్
where is this? Uh, hotspot. ఎంతవరకు వచ్చింది మూడ్ కోట్ ప్రిపరేషన్ మండేనే కదా as of now no intimation. It's working day. We'll see. వర్కింగ్ డేనే ఇంతవరకు రాలేదనంటే వర్కింగ్ డే. ఎంతమంది మా ఇక్కడ పార్టిసిపేట్ చేసేది మూవ్ కోర్ట్ లో? జస్ట్ రేజ్ యువర్ హ్యాండ్స్. హౌ మెనీ ఆఫ్ యూ ఆర్ ఇన్ మూవ్ కోర్ట్ కాంపిటీషన్? Oh, very good. మెమోరియల్ సబ్మిషన్ అయిపోయిందా? మూడ్ కోర్ట్ టిప్సా? ఓవర్ మోటివేషన్ పనికిరాదు. వద్దు శర్మ. సరే, I have a question for you. Yes, yes. Second half, second half. I have a question. I have a question for all the students here. A very general question relating to will. 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 Okay. You have already studied Indian Succession Act. You have already studied the law relating to will. అవునా? టీపీలోనూ చదివారు, దాంట్లోనూ చదివారు. సరే, I'll give you a situation. I'll give you a problem. Okay? Listen to it and let me see how many of you will answer. A Christian male executed a will in favor of his brother. A Christian male executed a will in favor of his brother. After a year, he got married. Ochenda, chusava? I just came across this problem, okay, in social media. Nah? So this question is not for you, Sharma. It is for, let me see. So he got married After execution of will, he got married and a child is born to him. Later he died. He died, leaving his widow and child. Can the widow succeed to the property of her deceased husband, or the will prevails? Is the question. అర్థమైందా? క్వశ్చన్ అర్థమైందా? సంతోషం. Will she get the property of her husband, or the property goes to his brother? అనేది ఇక్కడ క్వశ్చన్. Anyone from girl side can answer. Yes. Can anyone answer? You can discuss, you can share. None. చెప్తారా? Shiny చెప్తావా? Will you answer my question? No. இல்ல நீ என்ன சொல்றியோ எனக்கு புரிஞ்சுது. இல்லையே, உனக்கு ஃபேக்ட்ஸே இன்னும் புரியலையே. எப்போ பில் எக்ஸிக்யூட் பண்ணாங்க? கல்யாணத்துக்கு முன்னாடியா கல்யாணத்துக்கு அப்புறமாவா? மைக்கு Indian succession. Indian succession Act. இப்போ ஒரு பில் எக்ஸிக்யூட் பண்றாங்க. ஒரு பில் எக்ஸிக்யூட் பண்ணும்போது அவங்க வந்து உங்களுக்கு நான் எழுதிக்கிறேன்னு சொல்லிடுறாங்க. பட் அந்த பில்ல வந்து எப்போ அவங்களுக்கு வருதுன்னா, அந்த பர்சன் எழுதி வச்ச பர்சன் இறந்துட்டா அது வந்து அவங்களுக்கு வந்து சொல்றோம். பட் அந்த பர்சன் இறந்ததுக்கு அப்புறம் டெத் சர்டிஃபிகேட் ப்ரொடியூஸ் பண்ணி அந்த ப்ராப்பர்ட்டியை நாங்க சேல் பண்றோம், இல்லைன்னா எமோட் பண்றோம், பிளட்ஜ் பண்றோம், இந்த மாதிரி நாங்க பண்றோம். பட் ஆஃப்டர் மேரேஜ், பிஃபோர் மேரேஜ் டிஃபரன்ஸ் ஐ டோன்ட் நோ த பேட்டர்ன். பட் காமன் திங், பில் எக்ஸிக்யூட் பண்ணிட்டாங்கன்னா அவங்க அந்த பில்லை எழுதி கொடுத்தவங்க இறந்துட்டாங்க அப்படிங்கிற பட்சத்துல டெத் சர்டிஃபிகேட் ப்ரொடியூஸ் பண்ணி அந்த பில்லை எழுதி கொடுத்தவங்க வந்து உரிமை கொண்டாடுவாங்க. இதுதான் நான் லாஸ்ட் வீக் கூட ஒரு பில்லுல இருந்து ஒரு டாக்குமெண்ட் பண்ணிட்டாங்க. லாஸ்ட் வீக் சரி, Anyone? Anyone else? No claps. No claps. யார் கிளாப் அடிச்சாங்களோ அவங்க நின்று ஒரு வாட்டி பதில் சொல்லலாம். Then others will clap. Anyone? So you want to share? Ma, you pass your mic to Sir.
Good morning. This is from Akari for Indian Census. Today, it is once the whole house, it is presented to that person. There is one brother is Mexico, and Bill Mexico is brother and everything. Well, he will not marry in up his after the incident, it comes under roads mark his property. After his getting married, it will be over. It will not feel as a formal function. Will be revoked. Revoked.
Okay.
After this, getting the marriage.
Did you read revocation of will? Huh? 69 or 169? 69. Revocation of will. Once you go through that now. Okay. This is not finding fault. This is all a learning process. Because last week you just said that last week you have gone through some will case. Serima, under what situations the will gets revoked is another clause, right? So you need to know when will gets automatically revoked, revocation by the party, and automatically getting revoked is another situation. By default, it gets revoked. Hair ochar kada, legal hair. Both properties can be Hindu Succession Act lo undi kada. Through testamentary succession, చేయొచ్చు. Once get partitioned, it becomes separate property. You want to answer? No, he has answered on your behalf. Okay. Shall I ask another question? You have a basic question. You ask that question to your friends. Yes. Let us see whether they can answer or not.
So, question was when we are executing a bill, that is present or not.
Listen, everyone. This is for you. This question is for you, not for me.
But the basic question is when we are executing a will, on let us take an example. In this case only. So since he executed his will on his brother's name and he died, and does his legal representatives have a chance to revoke the will? Because whenever a will is executed, it is again vested to him. He can revoke the will at any time in living. And the problem here is, does that legal representatives have the same chance of revoking the will? Because almost every right is transferred to the legal right, legal representative.
Anyone can answer. Yes. Ella can revoke.
My question is only simple
This
one
is
thing.
another situation.
Either we revoke or not. We have that right or not. We have that capability or not. Simple, yes or no. That they are legal hands. Yes, legal hands, legal representatives have the chance.
Take this way. Take this way. Okay, after marriage he executed a will. Not before marriage. After marriage, X executed a will in favor of his brother, excluding the heir, legal heir. Okay. Yes. And legal heir was not aware of making of such will and all. After the lifetime, he comes to know. Now, continue with his question. Can the legal heir challenge the will executed by his deceased father? Can the will be revoked? Huh?
In the legal representatives have all rights to revoke the will on behalf of the deceased person.
Nah.
So you mean to say that there is a two scenarios here. So once executed the will, if the person dies after execution the will, so automatically the property goes to that will person. Okay, there is a one scenario. And another one is legal has is also here. Okay, so there is a legal has. It's a question mark actually.
Come with an answer. What? Come with an answer. Whether they can. ఇది question mark కాదు. Yes or no? Say yes or no. No. Yes.
Yes.
Yes, sir.
Yes.
We'll see. We'll see. If I get a chance, I'll come with a few more complicated examples.
Okay. My time starts now. Your time is over. Isn't it? Huh? So allow me to discuss on today's topic, social integration. Though this term is not there, but the topic which I am going to discuss today, it comes under social integration. Social integration, that is a Hurlo and Pyro. Two concepts we will discuss as a continuation of our discussions. So let us discuss about this furlough and payroll. We know that crime is a part of our society, isn't it? Society is developing along with crimes, and crime trends also trends. If you find, if you visit National Crime Record Bureau data will find every year the trend line of crimes increasing. So crime is a part of our society. Without crime, there is no concept of no society. So society and crime, the mechanism to control this crime, that is different things. But the crime is a part of our society. But as I told you that the reaction and the response to the crime, which we are going to discuss, makes the different the criminal justice system global generally. It makes the difference how you are handling or maintaining these criminals in the society. That is the things. So administrations of, and who is that, who is dealing with this, the criminal justice systems, this criminal justice administration, the institutions of criminal justice administrations. So such criminal justice system plays a crucial role, a significant role, an important role in shaping the understanding of society's response. What is that society response? As I told you that, because when your behavior is accepted and when your behavior is not accepted, society's response. So towards this crime and criminals. So with the changing needs of this globalizing world, because society is changing very fastly. Now we are in the modern technology era. We are in the threshold of globalizations, modernizations, urbanizations, and industrializations. So in this era, with the changing needs of this globalizing world, the idea of this criminal justice system had also made a shift from what? From giving harsher punishment towards that how to reform, rehabilitate, reintegrate the justice systems, the criminal crime and the criminals. That is their idea. Now they are working on these things. How to rehabilitate, how to restore the life of criminals, how to restore the life of a victims in the society. Now they are working continuously, monitoring, working, observing on this issue. These are now the concept of research. Now this debate is going on. It's not a continuous process. How they will give the better justice to a victim, how they will reform and rehabilitate to the offender, simultaneously. So victim as well as the offender, they are giving importance both the sides, because this both are important for the society, isn't it? So the purpose of, that's why this purpose of reformatory theory is to what? As I told you that, to reform the offender as law abiding citizens. That is the reformative theory introduced. Reformative theory, the concept is, earlier what was the idea was that an eye for an eye, tit for tat. He committed that murder. He murdered that. Let us murder. Now this idea changed. Now this idea of the society is changing. So suppose a person, as I told that, what I told that, no man is born as criminal. It is the society, the surroundings, the environment, the situation, the positions turn into a man a criminal. Isn't it? So when he committed a crime, he committed a mistake. Let us rectify that. Let us reform that things without giving the harsher punishment. This is the idea of now the society, the criminal justice administrations. Not like that we will reform when an habitual. Think of about a habitual offender. Don't think about the others, those who are committing crime again and again in the society. What about how we will change their mindset? We cannot do that. So that's it's now the debate is going on, discussion is going on. The works of monitoring continuously how we will control the crime and how we will give the justice to the victim. That is the idea. So the purpose of this reformative theory is to reform the offender as a law-abiding citizen. From the day one, I'm telling you that we are discussing the same thing. The reformative theory, what it says, how to make him a law-abiding citizen. How to not a violent of this, not a violators of the law, not as a lawbreakers. So that is the idea. So the concept, this beautiful line given by the our father of our nation, Mahatma Gandhi, he said that an eye for an eye will turn the whole world blind. Suppose a person committed a crime, what is the idea? If we kill him, then what the another person will commit crime? What will do? You will kill and you will send him up. So that what will automatically, so he said that. So this is the trust area of the research. This paves the way for thinking again and again for reformative system, rehabilitative system, reintegration system. His idea, the beautiful line given by Mahatma Gandhi. So an eye for an eye will turn the whole world one day blind. So the essay also the what is that? Justice Krishna Iyer. What he said that? He said that every saint has a past and every sinner has a future. Every sinner has a future. So from if you will consider this two idea of two different persons, this reformative and rehabilitative is come forward. So their idea is how to reform and rehabilitate, reintegrate the offender in the society. Okay, so they coming to this ultimate goal of the imprisonment. Why punishment? Why punishment? Imprisonment to deter the offender. To deter the offender. So to mainstream the person who has committed the crime or who has derailed from the mainstream of the society. Isn't it? Who has derailed? Who is not ready to accept the law. So this, the entire system, the ultimate goal of a imprisonment is to mainstream the person in society, and which cannot be possible without was providing him an opportunity. What type of opportunity? What type of, because now he is in the jail. How he will get that opportunity? How he will avail that opportunity? And how this monitoring, the jail administration should implement this idea. That is the, today we are going to discuss about this. Because without giving an opportunity to a prisoner, an offender, a criminal, a wrongdoer, how we will think of about the society, how we will give justice to the offender. That is the idea behind this concept, today's concept. That is the idea. How we will give justice. He has committed a crime. Now this role of the society is to reform him, so that when he will come out from the jail, he will lead a peaceful life. And how he will lead a peaceful life, and he will come out as a law-abiding citizen, so that further he will not commit, he will not involve in any criminal activities in the society. That is the idea. So therefore the law makes the provision for social reformation and reintegration by providing him this idea, furlough, parole, opportunity to stay in the open prison concept came into existence. After that, open prison system, and to provide assistance after care. These are the four important parts of this reformative and rehabilitative theory regarding the prisoner. So let us discuss about what is the idea of this furlough. This furlough is nothing but a leave. Leaves, the sanction leave, they will apply that. But what is the procedures for leave this? Let us release of prisoners on furlough. Furlough and this is a furlough and parole. Two concepts. Another one is if your behavior is good, then they will send the open prison where no restrictions. That does not mean you will come to Tirupati market or Reliance, you will go, you will purchase this, that, and you will come. That is not. Open prison. Open prison. Here, the idea is different. Open prison, there is no restrictions. No restrictions. You will lead a peaceful life there. Here, restrictions. This time to this time. There are no restrictions. So there is the idea is different from this open prison and this normal the prison systems. Okay. So this furlough is known as the temporary leave. Temporary leave. Home visit or temporary community release. So grant of furlough to the offender in extreme circumstances. What is that? Or the special circumstances. What is that? What is your idea about this extreme circumstances? Then only a prisoner is allowed to avail this furlough. What is that? What is that? This extreme circumstances or the special circumstances. Suppose you are the only male member in your family. Suppose a prisoner is the only male member in the family. Father, a family member passed away. Extreme circumstances. No one is there to take care of the family members. No one, the society or the neighbors, they are not coming forward to protect the family. Under these circumstances, under these special circumstances, he will apply. Suppose father is not there. Remember, father is not there, but he is there. But his mother is hospitalized. Who will take care? Who will take care? No one. So extreme circumstances or special circumstances, this system is allowed to a prisoner to avail this opportunity. So, and often the inmate must be, the procedure is, he will be assessed by that, what is that? A temporary officer as a part of terms of the temporary release. An officer will assist him. The jail authority will appoint an officer who will assist him for temporary leaves. Temporary leaves. That this is the procedures of this sanctions of this furlough. Now coming to the another part of our discussion, that is a prisoner on special leave typically travels under escort. As I told you that, while on furlough is on his own. So this prisoner on special leave when parole, when a prisoner will apply for special leave. Special means granted in the case of parole. Parole means the special leave. Parole means a special leave. So in the case of the parole, the typically travels under escort. While on furlough, he is on his own. So coming to another important thing which we should know, that this furlough is the right but not absolute. What does it mean? Instead of, what is your idea? This furlough is the right. You have right. A prisoner have right to avail this furlough, this leave, but not absolute. Fundamental rights are like this. This furlough is, though you have the rights to avail this opportunity, furlough, but it is not absolute, subject to some conditions. Subject to conditions. What is that condition? That condition is, number one, your behavior should be good. Good behavior. Your conduct is good. Behavior. So this ordinarily, if the prisoner wants to claim any sympathy, read the following lines, that next paragraph. So if the prisoner wants to claim any sympathy on humanitarian grounds, before he so desires, he will have to qualify himself to deserve it by his what? By his conduct, by his good conduct and behavior in and outside the jail, in and outside the jail, and which is entirely in his hands only. So, and not with the jail authorities. So he has to prove that. As I told you that, what is that? Prover. Yesterday, the probation. What is the meaning of to prove? What do you have to prove? You have to prove that you are worthy for this, not to punish, not to punish, not for punishment, not for punish. You are worthy for now. You are not deserving that punishment because you changed, you transformed yourself inside the jail. You transferred yourself. You changed a law. Your behavior is now good. So that is the idea. So the court, while deciding, the procedure is the court, while deciding whether accused can be granted bail, parole or furlough, held that ordinarily in rarest cases, as I told you that in rarest cases, when there is violations of constitutional rights, the High Court may grant parole or furlough. When there is violations of constitutional rights, when you are in the custody of an authority, but there is a violations of your constitutional rights, your guaranteed rights, then the court will take the decisions and will allow for furlough. So the breach of, now it is on the part of this, on the part of the offender when he will go on furlough. So the breach of conditions for suspensions of sentence, as I told you that parole or furlough, there is a conditions applied subject to absolute, as I told you, subject to condition. What are those conditions? Those conditions are laid down in jail manual. If you want to apply, then you have to satisfy, you have to fulfill the conditions which are laid down in jail manual. In jail manual, that is, you have to satisfy that. You have to fulfill that jail the conditions. So if you will, that means you accepted the jail, the conditions. So if you will violate those conditions when you will came out, you suppose you violated that, what will happen? There is a provisions, sections 48 prison of the Prisons Act. Under these provisions, the prison authority, they will immediately file a case against you and sentence on parole or declared as prison offense under 48A. And in case of any such breach, the superintendent of the prison is empowered to give the punishment to you, and he will immediately file, report to the police, file a case, that will be also considered. This is the provision is there under this Prison Act, section 48A, which deals, which says about this breach of the condition, breach of for the suspensions of sentence. Now, in Magan Bhai, Prasang Bhai versus State of Gujarat, these are the Honorable Court, the Gujarat High Court observed that we are quite conscious of the fact, that the furlough is an important conditional right. As I told you that though you have right, but it is subject to certain conditions. Certain conditions apply. Okay, certain conditions apply. So we are quite conscious the observations made by the Honorable Gujarat High Court in this case in Magan Bhai versus State of Gujarat in 1994. The observations of the court is like this. We are quite conscious of the fact that furlough is an important conditional right of the prisoner, and that as far as possible it should be granted. Yet at the same time, our sympathetic humanistic approach to the prisoner cannot be allowed to take the driver's seat to control our judicial discretion. That does not mean it allowed to the whom, to the offenders, to misuse this rights, misuse these rights. So overlooking altogether equally important, if not more, the public interest involved. Then this is all about your full. Coming to the another part of our discussion, that is the parole, which is special leave. Special leave, it is not leave, special leave granted to the prisoner. So under that there are certain conditions also, but the both measures are, both policies are, both these are the, it is a mechanism to rehabilitate, reform the criminals, inside the jail. So coming to the concept of parole, this parole is one of the novel concept the idea introduced with a novel cause. For what? Of implementing these rehabilitations and reformative measures in the correctional process of jail reform. Jail reform. So it is a reformation which helps the idea, the concept, the thought behind this parole is that it helps the prisoners to reintegrated in the society. Because since long time he is in the jail, he has no the direct contact with his family members. So if you will allow this, if you will allow him to meet his family member, so the family members will relieve in some extent. So this is the idea of the criminal justice administration. So it is a reformation which helps the prisoners to reintegrate in the society, which helps in social rehabilitations. So when finally when he will come out from the jail, he will adjust. That day I told you that he will readjust himself in society once again, and he will be able to rehabilitate himself in the society. So this is the parole has emerged in one of the most for this purpose. This concept, this idea of parole has emerged as one of the most acceptable form of correctional device in modern penology. So it is a provisional release. It is a provisional release from confinement, but is deemed to be a part of the imprisonment. So release on parole is considered as a wing of the reformative process, as I told you that, and is expected to provide the opportunity to the prisoner to transform himself into a useful citizen, law-abiding citizen. It will be useful so that he will readjust himself in society when he will come out. So it's a part of this, it's an integral part of this transformative system, reformative system, reformative system. So parole is thus a grant of, what is that? A partial liberty. So parole, if you find out that what is the dictionary meaning of this parole? Liberty. Liberate from this. Liberty. Especially if you'll find the dictionary meaning of this term, this word parole. So this parole is thus a grant of a partial liberty or lessening of restrictions to a convict prisoner. A convict prisoner. But release on parole does not change the status of the prisoner. As the first line itself, it is deemed to be a part of the prisoner. It's clearly mentioned. The guidelines. It's a part of the imprisonment. It's a part of the imprisonment, but not the change the status of the prisoner. Once after 5 days or 15 days, when you will return to the jail, the same status, the same things you will face. No change. So this is the thing. So the term parole is originated from a French word, je donne ma parole. It's a French word that means I give my word or word of honor. And in 1847, Sambel G. Ho, an American physician, he introduced this concept, this idea of parole. American physician who was working for the educations for blind in America. He introduced this word in 1847. Sambel G. Hoy from Boston for the first time used this word parole in a correctional context. So parole was later developed in 1876 by Bokwe Jebulon as a way of minimize the jail overcrowding system. Because in Corona time, what we observe? In Corona time, so the jail administration, they got confused. How to maintain this jail? How to send them? This problem. So when you will revisit, rethink about this probation, parole, everything, you have to mention this Corona time. So when situations arise, this type of emergency situations, how you will mitigate the system? That is the idea, basic idea behind this. How you will mitigate, how you will suppress, how you will handle that situations. This emergency situation, that is the importance of this discussion. That is the point to be discussed. Okay, so in 1947, as a way to minimize the jail overcrowding, while also rehabilitating convicts through their good behavior. So because now jails are, as I told you that day by day crime rates are increasing. Though these we have stringent penal provisions. We have stringent penal provisions. But after that also, if we'll see, if we'll study the National Crime Record Bureau data. Every time, every minute, seven rapes are committing in the society. It's happening in the society every minute. How those who are committing that crime, they knows very well there is a stringent penal provision. If I will commit the crime, one day definitely I will be penalized. So I am inviting that problems. After knowing that also, they are committing that crime. So this is the when we are sending that due to this to reduce the overcrowding in the jail. This concept also help the jail authority to reduce the overcrowding in the jail. Coming to the this historically, this parole is a concept known to military law. This idea paved the ways to the criminal justice administration to introduce in this justice administrations also in the field of justice administration. Earlier, this idea, the concept, the notions of this parole was where in military service. So and it was applicable to war crimes. So the and denotes the release of a prisoner of war on promise to return. So they will get because they will when in the jail, they will catch them and they will say, okay, after 2 years you go. So after 2 years, on the conditions that you will return, you will return. So this idea paved the way to this criminal justice system to implement successfully in justice administration system. So these days the parole has become an integral part. Slowly, the home department is when they introduced with a novel idea. Slowly now it got this momentum, and these days this parole has become an integral part of the criminal justice system. So intertwined with the evolution of the changing attitudes of the society towards crime and criminals. Okay, so it has been universally recognized now. Generally, all over country, they are applying, they are implementing this idea of this parole regarding what? Two things: to reform, rehabilitate the criminals, and another one is to reduce the overcrowding inside the jail. So it has been universally recognized as one of the most appropriate methods of treatment of offenders for their reformation and rehabilitations in the normal society after final release. Okay, this is the thing. So besides, it considerably helps in reducing overcrowding in prisons. These are the two basic ideas which pave the way to the criminal justice administration to implement this system. Coming to the another part of our discussion, that is the pathetic conditions of Indian prison. We know very well. There is overcrowding. I am not going to discuss this pathetic condition, what is going on inside the jail regarding this overcrowd. When you might have observed when you are during your jail visit. So the personality of a man behind walls and bars disintegrates under the strain of waiting for a decision in his case. We know that. We witness that. Daily we are witnessing this and or an order of his premature release from the jail. So the overcrowding in prison and increasing the versatility of prison torture is a serious cause of concern for those who believe in correctional penological philosophy. In 1955, the United Nations, under the guidance of United Nations, this how to maintain inside the jail or how to give them their rights, how to protect the rights of the inmates, the jail inmates, they discussed and gave an idea about this parole system. Further, in 1960, the UN Congress held in London, and it was stated that it should be customary that prisoners should spend later part of their sentence on parole. Finally, they said that in 1960, this UN Congress, which was held in London in 1960, so they said it was stated that it should be customary that prisoners should spend the later part of their imprisonment with their family members on the basis of this parole. So they are sentenced on parole or in open institutions which this paved the way for the concept of this open prison where they can live with their families. Now, one of the appropriate methods for a prisoner is to enter the community and participate in constructive work is to place them in open prison or release them on parole. Now let us discuss about the judicial trends, the observations made by the Honorable Supreme Court and also the High Courts, different High Courts in India. Let us discuss what is their idea behind this concept of this parole. The 2-3 case I will tell you that where we will discuss. In Punam Lata versus Wadawan, that is in 1987, the Honorable Supreme Court defines parole as the release of a very long-term prisoner from a penal or correctional institution after he has served a part of his sentence under the continuous custody of the state because he is in the jail and under conditions that permit his the imprisonment in the event of misbehavior. This is the observation made by the Honorable Supreme Court in Punam Lata versus Wadawan. The judgment came in 1987. And another case law that is in Dado Tulsidas versus State of Maharashtra. State of Maharashtra. The Honorable Supreme Court further said that in this case, Dado Tulsidas versus State of Maharashtra in 2000, the Honorable Supreme Court observed that parole is not suspension. I have already mentioned. Remission or commutations of sentence. Then what is? It is a special leave. It is a special leave only. Convict continues to be serving the sentence despite granting parole. Once after the completion of the 10 days or 15 days, the parole days, once again he will come to the jail to serve his imprisonment. He will continue. There is no special status given. Now you came from outside, no special status. No special status, nothing. The same, he will continue as a prisoner only. Like so, a convict serving imprisonment sentence is only entitled to parole. Now, coming to the another judgment of this is the Babu Singh versus others. Justice Krishna Iyer. He said that if the state is of flexible nature, parole for longer period can be issued. But for your information, there is no proper rules for that. It depends upon the state to state. It differs from the state to state. There is no proper rules and regulation how many days the state of Tamil Nadu they will allow, the state of Andhra Pradesh will allow. It differs from the state to state. That's why the government constitute a committee to find out a solution for that. So that we will frame a rule on for how many days it will grant the parole for how many days. That committee constituted a committee. So this Justice Krishna Iyer made it clear that if the state is of flexible nature, parole for a longer period can be issued, which is way better than giving full bail. As here we have vigilance over the prisoner, because here also we are monitoring the when he is going outside. It will reduce our overcrowding, the prison numbers in the jail, and it will reduce our burden also. So let him go outside. So this is the things. And in another case also, in Gudikanti Narsimelu versus the public prosecutor, the Honorable Andhra Pradesh High Court, Honorable High Court of Andhra Pradesh said that in keeping a person in harsh and inhuman condition not only harm the persons physically or also mentally, hence to maintain the human feelings, the vibes as accepted in constitutions, parole system is important. This parole system is important because we should understand the feelings of a prisoner. Now because he is under our custody. So the state, the jail authorities should consider the feelings of the prisoner with regard. That's why they introduce this parole system. Hmm. Hmm.
Like Subhash Chandra Bose.
So this, as I told you that this parole also, there are certain conditions will be applied. As I told, that's why this parole, though it is a right, but it is not absolute. Subject to condition. What are those conditions? What are those conditions? No, though you are going, you have to report every evening. You have to report to the nearest police station. Without prior information, you have no right to travel to the other parts of the country. You have to inform. No, suppose that is the when the police will file a case once again. These things are happening in our society. These things are happening in the society. They are absconding during their time. Then it is the duty, accountability, responsibility of the police administration to find out, and once again they will file the case and send it to jail and bring to the notice of further. So this is one type of it comes under, because he's shown his real, what is that real nature. So they will next time they will not. And who will suffer automatically? An offender, a wrongdoer, a criminal. He will suffer inside the jail. This system introduced for the betterment of an offender, so that he can, when he will come out from the jail, he will easily in future reintegrate with the society, readjust with the society. Subhash Chandra was that time we had no proper technology. Now wherever he will go, our network following. Now that system, those no no that those during those period, the system administration was different. Now there was no such provisions. There was no such provisions, and he he was such a legend. Hmm. So, but now there are conditions. Wherever you will go, our network will follow. Absconding, definitely one day you will were arrested by the police. Once again they will fire. No issue of parole. There was no concept of parole. There was no, because as a freedom fighter, he was a freedom fighter. There was no such concept. He was not under the custody of any British. He fled from that situation. उसमें वहाँ आपका जो concept है ना, parole लागू नहीं होता. That time it was not there. The concept of parole, full pardon, probation was not there. Specially, not specially. He was a freedom fighter, So there was no. He fled away. What? To protect the interest of the citizen of India. To protect the interest of the citizen of India. So, okay. So with this, let us. So with this, let us stop here for today. Tomorrow we will meet once again with a new topic, new subject, and with a new idea. Okay. Thank you. Thank you very much for your patience. Our sir. Dear students, give me 2 minutes. Here is an important announcement for you, for your benefit. So please have patience and listen carefully. 2 minutes only, not more than that. Okay. Tomorrow is working day. Now why? Without, see, the concept is 2 days we got leave without wasting our valuable time, because we are here to learn something. We are here to learn something. So tomorrow, that's why let us make use of tomorrow, and after that we will consider your feelings. That is the thing. So tomorrow is working day. Another point is 15th April, 2 to 5 p.m. 15th of April, 2 to 5 p.m. Examination applications to all 5 years courses will be issued.
Note down.
Please kindly note down. all 5-year students. For all 5-year students, we are going to issue examination application form on 15th of this month, 15th April, afternoon only, 2 to 5 p.m. All 5 means honors also including that now, my dear. Coming to next, 16th April, please remember. Don't forget. Don't ask us again and again, okay? Please remember. 16th of April, the very next day, for all 3 years courses, including general, honors, everything. Okay, 3 years general, 3 years honors. Please remember. Have patience. Please wait. Please, please. I'm coming to one by one. Okay.
We should concentrate on that.
So for examinations, submission of examination application form, you have to bring your SSLC, SSC, intermediate, and plus 2 certificate and one passport size photographs. Please. I'm repeating. 10th certificate, okay, plus 2 certificate, and one passport size photograph is mandatory. We have to attach. You have to bring, okay. One second, sir, because we have already kept there. Okay. Now coming to, listen, please, 1 second. Then original certificate which you have submitted at the time of admission. The original certificate will be issued to the students who has paid the complete tuition fees after 2:30 today. That is also today onwards, where in 4th floor, maybe 4th floor. Client, please, your original certificate which you have submitted at the time of admission, that certificates are with us now for verification, which you submitted for verification for higher education and other purpose. Okay, that today onwards you are allowed to collect if you have paid all tuition fees. If your tuition fees is clear, then you will accept that. You will receive that. We will issue that. In 4th floor after 2:30. After 2:30. Another important point. So many students are asking about that. Record and examination fees, both. Record and examination fees. Kindly note it down. The total fees is 10,000. Both record and examination fees. Record and examination fees, both 10,000. Okay. Coming to the another important information. In case of absence during this period, in case of absence, students has to pay a fine of 1,000 per day. Okay, understood. Coming to the another important information, students who has not attended any class should pay a fine of 18,000. Who has not attended single class due to their own problem or something, that he or she has to pay total 8,000. Totally not presented. 18,000. 18,000. Please remember. 18,000. I'm repeating the same. Don't ask us again and again. Then coming to the another information with regard to your records. Records and internals should be submitted on 3rd June 2024. 3rd June. Records and internals before examinations. You have internals also. You have internals. Okay. The last information. I think you will be happy to know that last working day 16th April 2024. So last working day 16th of this month. Yes.
1920 சார் என்னென்ன சொல்றாலும் நல்லா தமிழ்ல சொல்றேன் கவனிங்க. சரியா? நாளை நாளை வகுப்பு நடைபெறும். நாளை வகுப்பு நடைபெறும். கண்டிப்பாக நடைபெறும். ஓகேவா? அடுத்தது 15ஆம் தேதி நோட் பண்ணிக்கங்க. 15 ஏப்ரல் அதாவது மத்தியானம் 2 to 5 எக்ஸாம் அப்ளிகேஷன் ஆல் 5 இயர்ஸ் அதாவது BBA, BCom, BA 5 years honors, BA 5 years general இந்த 4 குரூப்புக்கும் 15th ஏப்ரல் மத்தியானம் 2 to 5 எக்ஸாம் அப்ளிகேஷன் கொடுக்கப்படும். அடுத்தது 16th ஏப்ரல் மத்தியானம் 2 to 5 all 3 years அதாவது 3 years general and 3 years honors க்கு அப்ளிகேஷன் ஞாபகம் வச்சுக்கோங்க. 16ஆம் தேதி மத்தியானம் 2 to 5 all 3 years. ஓகே. அடுத்தது எக்ஸாம் அப்ளிகேஷன் வரும்போது நீங்க என்னெல்லாம் கொண்டு வரணும்னா SSLC and +2 சர்டிபிகேட்டோட போட்டோ காப்பி along with ஒரு பாஸ்போர்ட் சைஸ் போட்டோ. எதுக்குன்னா எக்ஸாம் அப்ளிகேஷன் ஃபில் பண்றதுக்கு. இட்ஸ் மேண்டேட்டரி. புரியுதா? எதெல்லாம் மேண்டேட்டரி? 10th போட்டோ காப்பி and +2 போட்டோ காப்பி அதோட ஒரு பாஸ்போர்ட் சைஸ் போட்டோ கண்டிப்பா எடுத்துட்டு வரணும். அடுத்தது ஒரிஜினல் சர்டிபிகேட். நீங்க அட்மிஷன் போடும்போது உங்க சர்டிபிகேட்ஸ்லாம் கொடுத்தீங்கல்ல அது எல்லாமே இன்று மதியம் 2 to 5 உங்களுக்கு திருப்பி கொடுக்கப்படும். இன்று only today your original certificates எல்லாமே இன்னைக்கு மத்தியானம் 2 to 5 கொடுத்துருவாங்க. ஆனா சப்போஸ் நீ இந்த 3 இயர்ஸ்லயோ 5 இயர்ஸ்லயோ ஏதாவது ஃபீஸ் பெண்டிங் வச்சிருந்தீங்கன்னா உன்னோட ஒரிஜினல் சர்டிபிகேட்ஸ் ஹோல்ட் பண்ணிடுவோம். அதாவது தர மாட்டாங்க. சப்போஸ் yes and இன்னொரு விஷயம் ஆஃப்டர்நூன் ஜெனரல் ஸ்டூடண்ட்ஸ்க்கு ஃபர்ஸ்ட் சர்டிபிகேட் கொடுக்கணும். ஆஃப்டர் கிளாஸ்க்கு ஆஃப்டர் ஆனர்ஸ் கிளாஸ்க்கு நீங்க வந்து போய் உங்களோட சர்டிபிகேட்ஸை கலெக்ட் பண்ணிக்கலாம். புரியுதா? ஃபர்ஸ்ட் ப்ரிஃபரன்ஸ் டு ஜெனரல் ஸ்டூடண்ட்ஸ் மத்தியானம். என்ன சொல்றேன்? ஃபீஸ் டியூ இருந்துச்சுன்னா உங்களோட சர்டிபிகேட் தரப்பட மாட்டாது. புரிஞ்சுக்கோ. ஃபீஸ் ஏதாவது பெண்டிங் ஏதாவது வச்சிருந்தீங்கன்னா உங்களோட சர்டிபிகேட்டை ஹோல்ட் பண்ணிடுவோம். அடுத்தது இன்னைக்கு நான் கிளியரா சொல்றேன். இன்னைக்கு மதியம் 2 to 5 ஓகே. அதாவது 2:30 சாரி 2:30 மணில இருந்து 5 மணி வரையும் உங்களோட சர்டிபிகேட்டை நீங்க வாங்கிக்கலாம். அவங்களே செக் பண்ணாங்க. சப்போஸ் உங்களுக்கு ஃபீஸ் பெண்டிங் இருக்குன்னா உங்களோட சர்டிபிகேட் ஆட்டோமேட்டிக்கலி ஹோல்டட். அடுத்தது உன்னோட ரெக்கார்ட் ஃபீஸ் இன்க்ளூடிங் உன்னோட ரெக்கார்ட் ஃபீஸும் எக்ஸாம் ஃபீஸும் சேர்த்து 10,000 ரூபாய் 10,000 rupees. புரியுதா? ஞாபகம் வச்சுங்க. உன்னோட ரெக்கார்டும் பிளஸ் எக்ஸாம் ஃபீஸ் 10,000 ரூபாய். அடுத்தது சப்போஸ் இந்த ஒரு மாசத்துல நீ எத்தனை நாள் லீவ் போடுறியோ சப்போஸ் சில பேர்லாம் ரெகுலரா வந்திருப்பீங்க. ஒரு 2 நாள் லீவ் போட்டிருப்பீங்க. அவங்களுக்கு எப்படி கால்குலேட் பண்ணுவாங்கன்னா per day 1,000 rupees ஃபைன். நீ 2 நாள் லீவ்னா 2,000 rupees நீ பே பண்ணணும். ஒரு நாள்னா 1,000 rupees. ஒரு 4 daysனா 4,000 rupees. புரியுதா? and ஒருத்தர் கூட ஒரு கிளாஸ் கூட அட்டெண்ட் பண்ணாதவங்களுக்கு 18,000 ரூபாய் ஃபைன். 18,000. ஒரு கிளாஸ் கூட பிகினிங்ல இருந்து எண்ட் வரையும் ஒரு கிளாஸ் கூட அட்டெண்ட் பண்ணாதவங்களுக்கு 18,000 ரூபாய் ஃபைன். ஓகே. அப்புறம் உன்னோட ரெக்கார்ட் கொடுக்குறாங்கல்ல ரெக்கார்டும் இன்டர்னல்ஸ். உங்களுக்கு இன்டர்னல் எக்ஸாம் கிடையாது. யூ ஹேவ் நோ இன்டர்னல் எக்ஸாம். உனக்கு இன்டர்னல் புக்லெட் கையில கொடுத்துருவோம் along with ரெக்கார்ட். சோ நீ வந்து ஜூன் 3 ரிட்டன் ஜூன் 3 வரும்போது நீ வந்து ரெக்கார்ட் along with இன்டர்னல்ஸ் சப்மிட் பண்ணணும். சப்போஸ் ரெக்கார்ட் நோட் வந்து ஃபுல்லா ஃபில் பண்ணீங்கன்னா your record will be cancelled and again next year you have to come. And handwriting variation. ரெக்கார்ட்ல handwriting variation I know நிறைய பேர் மற்ற பசங்க கிட்ட கொடுத்து ரெக்கார்ட் எழுதுவீங்க. அப்படி எழுதுனா we will catch you. Kandipa, we will ask you to write. Then we will compare your record. If we find anything, immediately we will cancel your record. Then we will give you 0 mark. Clear? Adhe mari internals no. So write on your own. You have 1.5 month leave. Okay. So finally, your class going to complete on 16th April. April 16 உங்களோட class முடியுது. Okay. அதுக்கப்புறம் record fees 10,000 mark.
With exam application.
With exam application. See that you should see for 15th when you are paying for 5 years 15th தேதி அப்ப you will be getting your record note along with your internals. So 16th 3 year students you will be getting your record as well as your internal booklets. No internal exam. You have no internal exam. Instead, we will give you and you have to write and give it back. எப்போ சப்மிட் பண்ணோம் ஜூன் 3rd. கிளியரா? ஏதாவது டவுட் இருக்கா? அவ்வளவுதான். ஓகே? வெரி குட். சப்போஸ் நீ வந்து கான்வெகேஷன் சப்மிட் பண்ணலன்னு வச்சுக்கியா உன்னோட C1 வந்து கிளியர் ஆகாது. C1 னா என்ன? கிளியரன்ஸ் ஃபார்ம். கிளியர் ஆகாது. So try to submit your convocation and migration. Yeah, when you are paying your exam fees, அப்போ வந்து உன்னோட convocation migration ஆபீஸ்ல சப்மிட் பண்ணனும். இல்லாட்டி உங்களுக்கு provisional certificate வரவே வராது. ஜூன் 3rd ல இல்ல exam fees pay பண்ற டைம்ல you have to submit your convocation and your migration certificate. That's your problem. And one more announcement. 3 years honors and 5 years honors. Your original certificates will be given tomorrow afternoon 2:30 p.m. So don't rush today. You got me? You have afternoon class. Please attend your afternoon session and your original certificates will be given only tomorrow for 3 years honors and 5 years honors. புரியுதா? 3 years honors 5 years honors நாளைக்கு தான் உங்களோட original certificate கிடைக்கும். சோ இன்னைக்கு போய் நிக்காத. புரியுதா? டைம் கிடையாது. நீங்க எவ்வளவு டிலே பண்றீங்களோ உங்களோட certificate டிலே ஆகும். புரியுதா? Do you have any doubts? For your information, those who studied interstate, I mean Andhra Pradesh students, you need not to submit your migration. Andhra Pradesh students, you need not to submit your migration. Those who studied other state, Tamil Nadu la Andhra vandrukingala, Kerala la Andhra vandrukingala, நீங்களா migration certificate கண்டிப்பா கொடுக்கணும். But producing 3 years honors and 3 years general convocation is mandatory. If not, your C1 things will not be clear. அப்புறம் நீ பின்னாடி சுத்தணும். சார் என்னோட பொசிஷன் வரல. ஏன்னா நீ காம்ப்ளிகேஷன் ப்ரொடியூஸ் பண்ணல. அதனால உனக்கு போகணும். Okay. For SP students, university students, those who have taken your UG in SP university, you need not to submit your migration. Clear? So within this, we'll wind up morning session. Now, 5 years girls, please move to 4th floor. 5 years girls, please move to 4th floor. There should not be any confusion because already principles are announced and I have translated. So hereafter you should not have any confusion. Okay? Five years girls, please go to 4th floor. Both boys and girls. Boys Boys, kindly wait till girls leave. Those who are standing outside, please leave the space. Please leave the space. Exam is paid. Okay. Migration.
இப்போ சர்டிஃபிகேஷன் வாங்கிருக்கோம்.
டிலே பண்றீங்களா அவ்வளோ
சர்டிஃபிகேட் வாங்கிருக்கோம். அதுக்கப்புறம் நான் மைக்ரேஷன் சர்டிஃபிகேட் கொடுக்கலாம்.
மேடம்
Previous number 1 to 21.
ஆல்ரெடி அப்ளை பண்ணிருக்கோம். யூனிவர்சிட்டி யூனிவர்சிட்டி ட்ரான்ஸ்ஃபர்
Others, please step back to your places.
one more name submit exam fees please form it please 10,000 ஆல்ரெடி அப்ளை பண்ணாங்க மேடம் வைஃபை கனெக்ட் சார் சார் மைலேஜ் சார் அவங்களே சொல்லுவாங்கடா எல்லாமே மத்தியானம் ஆப்ஷன்னாலும் ஆப்ஷன் தான் நீங்க அப்படி இல்ல சார் ஆல்ரெடி ஐ எக்ஸ்பிளைன் யூ கிளியர்லி தட் இஸ் ப்ராப்ளம் டவுட் வருதுக்கு என்ன எல்லாமே சொல்லிட்டேன்